recruit people who are qualified to be judges. That's being in practice for 10 years, legal practice. So whether they are soldiers or civilians, because that recommendation includes recruiting civilian judges for military courts. And then that recommendation has a clause, an underliner, that these judges who are now qualified can only try civilians in exceptional circumstances. They also put another underliner on that these exceptional circumstances must be presented to civil courts and present a condition that does not qualify civil courts to handle these cases. So that's what the order says as exceptional circumstances. In very simple English in that judgment. The third option was to say that these courts, also with the professional people managing them, should then be at a level of chief magistrate level, and another option. So the fourth one is the amendment of Article 129 to make military courts part of courts of judicature recognized under that article. So that they are then, because the Constitution is read as a whole. So when you put them in the Constitution, it means that they are bound by the principles of constitutionalism that govern all the other courts, that they are bound by the Trial and Indictments Act, the Judicial Code of Conduct, and everything that goes with courts as known. Of course, as I conclude, because I need to create space for the other colleagues, the most critical issues that court relied on in that decision were Article 28.1 on a right to a fair hearing, that goes with the protection of the independence and impartiality of judges, as well as safeguards for their jobs. So when it comes to the army works, it's a chain of command. And you don't question command. Even if your senior gives you a wrong order, unlike police where they say you can disobey an unlawful order, in the army you cannot. Order ni moja. So the courts are still embedded in that chain of command. The few cases where the defunct General Court Martial passed sentences, they had to consult with the president. So that means that the president wears robes of a chief justice when it comes to military courts as a chain of high command. So that is the biggest problem. The second biggest problem, as I conclude, is the function, how the courts function, the military versus civil. In civil courts, a criminal case is originated by a complainant, who can be a civilian or a state agent if you've committed a crime, or an organization. So you originate a complaint by making a statement. Police then investigates. When police finds that there's a prima facie case, they take the file for legal advice to the DPP, who is the public prosecutor. If the DPP confirms that indeed there are elements of criminality with the ingredients of the offenses and evidence, they sanction the file. And then the file moves to court. But what happens in the military court? The army is the complainant. The army is the investigator. The army is the prosecutor. And the army is the judge. Like, what kind of nonsense is that really? That Article 92 of the Constitution prohibits Parliament.
That's correct.
From reenacting any law that contradicts a decision of court. In this, they've done it before. When Section 23 of the Police Act was repealed under the Mwanga Chivumbi petition versus Attorney General, the NRM regime reintroduced Section 8 of POMA that has now also been repealed. So it has happened before, and Afanda, which was expressing the frustration of waste of time or money. Let me tell you, reenacting repealed sections wastes taxpayers' money in 4 forms. One is the money executive spends, like the judicial officers now in Attorney General's chambers, the Parliament, Legislative Council, to reenact and coach these sections, to reintroduce something declared unconstitutional. That's taxpayers' money. The time Attorney General is using and the movements is taxpayers' money. The sittings of Parliament is taxpayers' money. The sittings of court is taxpayers' money. So those are 4 forms of taxpayers' money spent to do something legally bogus. Then the citizens like us who do public interest litigation will be required to spend our own money. Yet we are paying tax for the bogus actions. To go to court and repeal the same bogus things they are doing. It's really, and I hope citizens understand the pain we are in, and we are going into elections. I don't understand. You know, I am pro-protest vote. This regime has nothing good to offer. Me, I am for the protest vote. Turn out and vote. Anybody not in yellow. I don't care whether it's red, blue, whatever. Vote out yellow, and we solve this problem.
I know.